Record, share. There we go. And slideshow. We
All right. Our group's presentation this week is going to be about all things liability and student records. Next slide, please. All right, so as we all know, schools keep a ton of information on students, things like grades, attendance, disciplinary actions, health info, test scores, etc. All of that is our education record. So, our group is going to talk about this week an important law that protects all of that called FERPA, or Family Educational Rights and Privacy Act. You may also hear it be called the Buckley Amendment. FERPA was passed in 1974 because Congress wanted to guarantee that our education records are kept confidential. It is kind of like a legal shield protecting your personal school data. It means the school can't just hand out your grades, your disciplinary history, or other sensitive information to anyone who might ask for it. Next slide, please. So in grades K through 12, FERPA gives parents the power over student records, meaning they can review and inspect education records. They can ask for changes and control who sees the records outside of the school district. Once you turn 18 or enroll in a post-secondary institution, such as college, those rights under FERPA transfer directly to the student. So suddenly you are given permission for your college to share your grades with your parents. So it kind of switches roles there once you turn 18. Why is this important for us to know as educators? It's all about fundamental fairness and control over information. It ensures that our students' records are maintained responsibly and that students and parents have a say in how private their information and how that information is used. Next slide. There we go. Since FERPA is a federal statute, it applies to school districts and schools which receive federal funds. This is really important detail because it explains how the federal government, despite education primarily being a state of responsibility, can enforce laws like FERPA. Essentially, the federal government uses its power of the purse if a school district or a school chooses to accept any federal funding, which is nearly all public schools and many private schools, like for special education or school lunches, they are then obligated to follow FERPA's rules. It's kind of like a strings attached deal. Like if schools take their money, then we have to then they follow our rules. So this means while states control the bulk of education, this federal law ensures a nationwide baseline for student record privacy for the vast majority of students.
All right. So when talking about FERPA and student rights and family rights, you do have to talk about the sanctions for violating family privacy rights. So there's a lot of things you have to do as an administrator, as in a school, to make sure that you're not violating anybody's privacy. So one of the excerpts of FERPA basically says that at a minimum, the school district needs to provide on an annual basis information to parents and guardians and students regarding the content of the law and inform them of the rights to file complaints with the Privacy Act Office of the Department of Education. So basically, you need to let your families know what records you have and how you use them. So this annual notification needs to contain the right to inspect and review records. Families need to know that they have the right to seek an amendment of those records if something is wrong or misleading, and that the consent to disclose personally identifiable information contained in a student's records, except where the law authorizes disclosure without consent. And of course, parents have the right to file a complaint as well. And parents need to know the procedures for exercising the right to review records, how to request an amendment. An educational agency or institution also needs to be able to notify parents and students who are disabled. So you have to be special with, you have to take some special precautions with students with IEP. And if an agreement is reached between parents and students that and schools that there does need to be an amendment, you can have that kind of meeting. And then you need to specify any criteria for determining who constitutes a school official. So you need to define that role. And then the one kind of exception to this is school districts can release directories of information that include things like name, address, phone number, birthday, but parents still have the right to reject this kind of information being published. Next slide, please. Now, if non-English speaking parents are affected under FERPA, the school has the responsibility to notify them in their native language. So you need to keep an eye out for that. Next slide. Now, as we kind of discussed in the first couple slides, parents have a lot of rights when it comes to FERPA. So the parents are legal guardians. They are the ones who have the right to inspect their child's record, and they can do it at any time. And a school official needs to be present to assist in that process to help interpret the information when that kind of comes up. And parents have the right to challenge the accuracy of any of the information that they have. And within 10 days, they need to schedule a conference with the appropriate school personnel. And in this meeting, if an agreement is reached, then it's amended and you move on with your life. But if agreement is not reached about the information in the records, if it's correct or not, parents can request a meeting with kind of your student services director, kind of that next level up within 10 days of that original meeting. And if at that meeting, the hearing decides that the information is accurate and correct, the parent can then provide an opportunity to place statements of disagreement in the file with reasons for disagreement. And they can also seek relief in a civil court if they really want to take it that higher level where parents, guardians, and students can kind of plead in front of a court. There needs to be consent form when releasing records that parents need to sign, and if they don't sign it, you can't release it. But if they do sign it and the records are released, you need to explain to them why the records are being released, and you need to emphasize that the information is not being divulged to others without express permission of parents and guardians. Next slide, please. Now, what you really have to be careful of is the rights of non-custodial parents. So that basically means parents who do not have custody of their children. And this was kind of settled in New York State with a case over there where a a child's father who did not have custody requested to see the information, but the parent with custody, the mother kind of blocked that, so the father sued. But the court basically came down and said that schools need to make educational records possible to both parents of each child who have custody. So if you don't have custody, that can kind of be controlled, but school and district policy kind of help set the stage here for what is possible.
All right, so these next slides are going to be talking about the rights of eligible students. So basically, students who are 18 years, or I believe in Nebraska, it's actually when they turn 19, which is a little bit unique. They have the same rights as the parents or guardians. And students may inspect their own records and challenge the accuracy of these records once they become eligible. They also have the right to decide who else besides themselves can view their records, and they would have the same due process rights as parents if they did decide to challenge the accuracy of their records. They could also bring liability charges for defamation against school personnel if they find that the information in their file is inaccurate. You can go to the next slide. So teachers, counselors, and administrators who have a legitimate educational interest in viewing records may do so. With that, they should place a written form that stays with the file stating who, what, and when the files were viewed, and anyone viewing the file stating who, what, and when, or excuse me, anyone viewing the file should sign this documentation. And if challenged, school personnel would have to demonstrate their legitimate interest in viewing that student's file. You can go to the next slide. In 1994, talks about how FERPA was amended to emphasize that schools are not prevented from maintaining records related to a disciplinary action taken against a student for behavior that posed a significant risk to other students or staff. This helps keep other schools where a particular student may go to have an understanding of the student that is coming into their school. A significant court case that came from this amendment happened in Ohio involving student discipline, specifically the use of corporal punishment. A student sued the Cleveland Municipal School District over a substitute teacher's use of corporal punishment, seeking the discovery of incident reports and student employee witness statements and information regarding subsequent discipline of the substitute teacher. The school district claimed that they did not have to grant access to those documents under FERPA, but the court found that FERPA was not intended to prevent the discovery of relevant records under the federal rules of civil procedure. You can go to the next slide. There it is. All right, so a number of states have passed laws protecting school counselors. However, most states do not support confidentiality protection for counselors. Michigan and Nevada have the most complete protection, while states like South Dakota, Missouri, and Oregon provide protections to counselors in civil and criminal proceedings. And then you can go to the next slide. And in states with no protections, counselors would be required to testify in court if ordered. School counselors are not required to share information obtained from students with their parents. Records that remain in the sole possession of the counselors are not subject to FERPA. Confidentiality is not always absolute. When circumstances arise in which public disclosure is in the public interest, confidentiality is lost. One of the most significant examples of this case was called Tarasoff versus the Regents of University of California in 1976. Essentially, what happened was a student confided to his psychologist during a therapy session that he was going to kill another student. And this student ended up going and killing this other student, whose name was Tatiana Tarasoff, who was obviously killed, and her parents filed suit claiming that the psychologist had the duty to warn their daughter of the impending danger, claiming that the psychologist's attempts at warning the campus police were not enough. The California Supreme Court ruled that the psychologist had the duty to warn that student that had been threatened, and not just let the police know. They should have actually taken steps to try and protect that student since they knew there was an impending threat to them. That's all I've got.
Okay. Enforcement of state or federal statutes. The law allows federal and state officials to inspect files without parental consent. This isn't a broad authorization for general access. Instead, it strictly limits to specific government functions in order to enforce federal or state laws, or to audit or evaluate federal education programs. Think of this as a necessary tool for oversight, ensuring compliance with regulations in the effective use of public funds in our schools. Okay. Building on the last point, even when these officials access records for legal or auditory processes, there's a crucial safeguard in place. The personal identifiable information, meaning data that can be linked directly to a specific student, generally cannot be associated with any student. This means they can look at collected data, analyze program effectiveness, or ensure compliance without identifying individual students. The only exception is if Congress, through a separate and a specific law, authorizes federal officials to gather and link identifiable data. This emphasizes the strength of student privacy protections under FERPA. So what exactly are these authorized federal state representatives? who have the specific access under FERPA. The law identifies a few key roles. The first is the Comptroller General of the United States. This is essentially the head of the Government Accountability Office. They're responsible for auditing how federal funds are spent. The Secretary, which is referring to the Secretary of Education, and administrative head of an educational agency. This would be a leader within the state or federal education department. And then finally, a broader categories of state and educational authorities. These are relevant state education officials who are responsible for oversight and enforcement. Um, as educators, on many occasions, we will be requested to provide information regarding a student. This could be verbally, like in a conversation with a partner, or a parent, or another colleague, or in writing, perhaps as part of a report or record request. Sometimes this information might come directly from the student's confidential file. Um, where is this qualified privilege comes into play? It acts as a legal shield for school personnel, specifically when such requests are made and school personnel respond in a truthful and reasonable manner in accordance with their prescribed duties. They are protected by qualified privilege, which means um, what this means is that if you are acting responsibly within your professional role, being truthful in the information you provide and doing so in a way that is reasonable in part of your job duties, for example, sharing information with another teacher who has a legitimate educational interest in the student, then you are generally protected from liability. Even if the information shared is sensitive, the privilege recognizes that open and honest communication among professionals is essential for a student's education and well-being.
All right, so qualified privilege protects educators when they share information about a student, but only if it's done in good faith. That means the educator must act with the sincere belief that sharing the information serves a valid educational purpose. If sensitive or damaging information is shared with someone who has no legitimate need to know, then that good faith is considered violated. This principle is important because qualified privilege is lost when information is shared carelessly or with harmful intent. An educator who fails to act in a reasonable and prudent manner could face personal liability if they breach this standard. Next slide. So to act in good faith, an educator must ensure that the purpose of sharing information is legitimate, meaning it directly supports the student's well-being or educational interest. For example, if a teacher shares a concern with a counselor or an administrator who is also responsible for that student, then that would be seen as serving in that common interest. What's critical is that the information being shared only with eligible parties for valid reasons and without any intention to harm the student. In cases like Zoll versus the state, the court emphasized that the absence of good faith, whether by intent or negligence, can lead to legal consequences for the educator. Next slide. So malice exists when there is an intent to harm or injure another individual. In a school setting, this becomes legally significant when statements, which can be either written or spoken, are made about a student with the purpose of damaging their reputation. If these statements are also false, they can constitute a act and open the door to serious legal consequences. There are two types of malice educators should be aware of. The first one is implied, which occurs when harmful statements are made without defensible justification. And then the other one is actual malice, which requires proof that the speaker had a specific motive to generate ill will or harm for the student. Both forms can result in liability, especially when educators fail to act with care or being professional with how they share the information. Next one. So even in difficult situations, truth can be a defense against liability, but only if no malicious intent is present. School personnel must be vigilant to ensure that all communication is fact-based, professional, and free of bias. Students have a liberty right to expect that their reputations are protected from unwarranted or malicious attacks. That's why statements should only be made when supported by defensible evidence and communicated in a way that is neutral and necessary. For example, when providing a reference to a prospective employer, it's essential to share only the information that was directly requested, nothing more. Doing otherwise could give rise to claims of malice. And that's all I got.
All right.